Hello, everybody, and welcome to Law Bite number 309, dated September 21st, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in. This Law Bite is entitled Constitutional Interpretation. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. In addition to that, please also hit the little subscription and notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, philosophy, and theology. Thanks so much in advance. Again, this video is entitled Constitutional Interpretation, and it was one of my final term papers as a graduate student in the Legal and Ethical Studies program at the University of Baltimore. Proud alumnus of that institution. All right, the course was in the spring 2018 semester. Course was entitled Democratic Legitimacy and the Rule of Law, taught by the exceptionally talented professor, Dr. Joshua Kasner. All right. And constitutional interpretation discusses the methods that are used by judges, lawyers, and academics, and even laymen in interpreting the U.S. Constitution, of which there is no solid, one defined rule on how to interpret that magnificent document. It is indeed, a very debated subject on how the U.S. Constitution should be interpreted. And this paper discusses that in great detail, all right? The controversy surrounding how the Constitution should be interpreted and the methods that are used to interpret the United States Constitution. So let's get right into it. So the United States Constitution came into effect, as we know, on the 21st of June, 1788, when New Hampshire became the ninth state to ratify the document, bringing it to life according to its own wording found in Article 7. Despite the presumptions of the average individual, it is a relatively short document, believe it or not, containing only 7 articles and, of course, 27 amendments. Outside of the amendments, much of the document itself is the result of extensive compromises made at the Philadelphia Convention of 1787. All right. While the Constitution speaks on many things, all right, it provides no official guiding tool on how it is to be interpreted. The closest primary sources of the day that we have that could point to any realistic degree of accuracy as to how certain provisions are to be interpreted, are the Federalist Papers, of course, which were papers written by Alexander Hamilton, John Jay, and James Madison to persuade the public to accept the then proposed U.S. Constitution. Ultimately, they did carry the day with that, all right? So, as such, throughout the nation's history, judges, academics, and legal scholars have all provided different theories for how the Constitution should best be interpreted, and as such apply to the American people. From these debates, 3 specific schools of thought have evolved with respect to interpretation, okay, and its connection to democratic legitimacy. These 3 schools of thought, all right, are as follows. Okay, you have Originalists, you have Textualists, and you have living Constitutionalists, okay? Each of these 3 factions, as I like to call them, has a distinct way that they read life into the U.S. Constitution. And Of course, as you would expect, each faction feels that its method is superior to the other two. This essay essentially expounds upon each of these methods of constitutional interpretation and shows their relationship to the rule of law and democratic legitimacy. So the first method we come to is originalism, okay? Now, as the name suggests, originalism, those who follow this school of constitutional thought, originalists seek to interpret the Constitution as it would have been understood by its readers at the time each article and amendment was adopted, okay? Now, with originalism, a schism exists in originalist thinking, all right? And that schism results from those who believe in original intent versus original meaning. All right, what do I mean by that? Well, original intent theorists seek to discern what each constitutional provision meant to those who drafted those provisions and, of course, ratified them subsequently as well, depending on the circumstance. While original meaning seeks to decode the meaning of constitutional text at the time the average individual would have understood it to mean. All right? So regardless of their positions, these individuals believe in looking backwards when interpreting the Constitution's text and shun philosophies which embrace modernist thinking and application to the centuries-old document. An originalist does not let contemporary interpretations or philosophical perspectives guide their judgments or interpretations, all right? The only thing that matters to an originalist, to an orthodox originalist, I'm going to say, is what it meant either to its drafters or to those who ratified it, one or the other. They will look to history, to references of the day, or even practices to give certainty and context to their interpretations, all right? Some have argued that being an originalist turns judges into historians, all right? I don't see what's wrong with that at all as a historian, all right? So some examples are as follows. The Second Amendment reads that, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. Now, an intellectually honest originalist interpretation of this amendment would likely draw a conclusion whereby everyday arms bearing would not be divorced from active militia service, all right? The original meaning of this, all right? Now, a living interpretation, which is the opposite, the whole opposite of an originalist interpretation, would view the operative clause of that amendment, which is the part that mentions bearing arms, with a more personal rather than militia focus, all right? These days, the militia focus would be all but dead to a living constitutionalist, okay? Which is rather ironic because if you all remember the Supreme Court's DC versus Heller decision in 2008, it was the 5 conservative members, several of which believe in the originalist school of thought, who essentially rewrote the Second Amendment via a modern interpretation, all right? Whereas it was the 4 living constitutionalists, the liberals, who took an originalist stance there with respect to what the Second Amendment was intended to do, prevent the federal government from disarming the state militias, all right? The personal aspect on the Second Amendment, individual right to bear arms, was certainly not the intent of the Second Amendment, all right? Personal protection of arms bearing would have been done by the state itself, not the federal Second Amendment, which was meant to only restrain the federal government from destroying the state militias, like I said. But that's covered in my videos on the Second Amendment if you want to check that out. So, back to the essay. Like with all belief systems, there are pros and cons to the originalist mindset, ladies and gentlemen, okay? Arguments for originalist thinking are as follows. First, As the Constitution provides no clear way on how it is to be interpreted, there is no legal counterweight to this form of interpretation, as it must be correct or it must be incorrect, all right? Number two, deference to the original principles of the law avoids a modernist view of the text, okay? And number three, because originalism limits judicial interpretation abilities, judges are somewhat forced to be intellectually honest when researching and reaching legal conclusions based on facts, not prejudice or alternative facts, okay? A fourth benefit of originalism is the stability that it provides in the law guiding subsequent decisions, okay? Precedents could be more consistently and permanently be established, and lawsuits could arguably be reduced, as outcomes would be far more predictable in all likelihood. Lastly, when the law has a solid, stable, fixed compass for interpretation, it provides the reliability and the security needed in a system without adequate checks on judicial overreaching, which our system is one of those, okay? The rule of law is also affirmed with the originalist interpretation, as it shuns arbitrary judicial decisions having no guidance or warrant from the letter of the Constitution itself. Okay? But all that glitters is not gold. Originalism has its downsides. Okay? Arguments against it suggest that given that the Constitution is more than 2 centuries old, okay, it is logically quite difficult at times, even with the understanding of context and even with some primary sources, to accurately decode all of its language perfectly from such a long time ago. I mean, let's face it, the Constitution has been in effect for more than 230 years, all right? It's a long time ago, okay? So it may not always be possible to decode exactly what the framers meant or what certain things would have meant to the average Tom, Dick, or Harry at that time, okay? So while one can make educated guesses after performing good legal research, it's still a guess at the end of the day, not a factual certainty. Another key weakness in originalism is that for those who subscribe to the faction of originalism known as original intent, it is merely a long shot to guess and assume what all of the legislators or drafters, who wrote a particular provision intended it to mean. Some may have felt it would have meant this, while others would have felt it meant that, or something else totally incomprehensible, all right? It is simply too far-fetched to come even close to a solid determination to suggest that some of these conclusions reached by originalist thinking are indeed authoritative and beyond all dispute, okay? Lastly, an originalist philosophy would likely render many parts of the document obsolete, meaningless, or insufficient for the modern era, as their original meaning would no longer serve present-day needs. This would require the constant and consistently difficult invocation of Article 5, all right, to add amendments to the Constitution, all right? And believe me, there would be a lot of them if Article 5 was invoked as often as it should be. So despite the drawbacks, the originalist interpretation pairs best with democratic legitimacy, however, all right? In spite of those drawbacks, it was my opinion that the originalist thought pairs best with democratic legitimacy, okay? With originalism, judges will tend not to be activist and invalidate laws in the name of progressive movements. After all, judges with this mindset look backwards and not forward, all right? The one exception in modern times that I recall was D.C. versus Heller when the court rewrote the Second Amendment, all right? The conservative, originalist justices rewrote the Second Amendment. So laws enacted in the name of the people by the way of typical democratic process will likely be sustained by the courts. Courts, in turn, preserve their adherence to the rule of law, not the rule of men, and thus sustain the democratic legitimacy of their decisions. In sum, originalists would never accept the concept of judicial amendments to the Constitution, instead promoting any substantive changes to come from the prescribed method in Article 5, the amendment process. Power is thus left in the hands of the American people to enact change. So many prominent jurists, such as Justice Clarence Thomas and Neil Gorsuch, both at the time of this recording members of the Supreme Court of the United States, tend to aim their jurisprudential philosophies around originalism. Most consistently, Justice Thomas, who, as you know, I've had the pleasure of meeting and having very, very informative conversation with on legal philosophies. So the second type of judicial interpretation falls into the school of textualism. Textualists arguably are the smallest group of the three, tending to lean more towards either originalism or the living document method. It is the practice of interpreting laws based on the precise and ordinary meaning of the written text. That is how textualism is defined. I'll read that again. It is the practice of interpreting laws based on the precise and ordinary meanings of the written text. Thereby, the focus is on what the words or phrases would normally be used for, okay? So additional or possible meanings are not typically considered. Statutory and constitutional language is often open-ended and vague, and thus a textualist may often run into issues finding a clear meaning for certain rules. Nonetheless, when language lacks precise clarity, okay, the textualist gives it the plainest interpretation possible without distorting the ordinary meaning of the word itself, okay? This group does not concern itself with the original legislative intent or legislative history of the law itself, viewing it as irrelevant. Similarly, the textualist does not naturally view the law as a progressive instrument to be used as a tool of social change. Remember, the textualist, at face value, does not take sides in this war, but rather follows the strict language of the text and gives life to it based solely upon what it says. Because of that, their interpretation could result in a seemingly originalist type of decision, and on other sides, a very progressive one. Trust me, I know what I'm talking about here. All of it, however, is the result of a plain meaning review of the text of the law. No frills included. Lastly, textualists do not feel that it is their place to rewrite or refine statutes. Some examples of a textualist reading of the Constitution are as follows. The First Amendment, which reads, quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances," end quote, is a formidable protector of some of our most basic freedoms. Indeed, the First Amendment is probably the most well-known part of the Bill of Rights, okay? So to a strict textualist, Congress and subsequently the states would be barred from making any law restricting the rights shielded by that amendment, all right? It does, after all, say no law. To a textualist, no law means no law. Doesn't get any clearer than that, right? Another example would be the 14th Amendment's Equal Protection Clause, which reads, quote, among other things, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. All right, 14th Amendment contains a lot more than that, but I'm just focusing on the Equal Protection Clause. To a strict textualist, that injunction is clear. All right, all persons within a state who are similarly situated must be afforded equality before the law. No exceptions, ladies and gentlemen. As with all types of interpretations, however, as we just did with originalism, the textual method has its pros and cons. Arguments for it include a lesser likelihood of reaching an outcome wholeheartedly inconsistent with the meaning of the words in the law, and in turn an outcome closer to the possible intent of its crafters, for better or for worse. Another argument for this interpretation is that it is not opposed by any formal guide on how the Constitution is to be interpreted. As the Constitution is completely silent, like I said, on how it is to be interpreted, it is technically just as correct as any other way. Arguments against the textualist philosophy contend, first, that the rigid textual interpretation of the document may produce results which, while correct, are not consistent with what the law was trying to convey, given how narrow the law would be read. Okay? Second, textual readings of many parts of the Constitution would significantly limit the legal effect of the law itself and its effects in other situations that may require a more expanded view and interpretation to provide an effective legal remedy for the problem at hand. Again, to update, the document would likely require the prescribed method, amendments created under Article 5, which of course is the proper way to change the text. Okay? Several prominent jurists include Justices Hugo Black, the late Justice Antonin Scalia, who we all know very well, and Robert Bork, a very prominent American legal scholar and federal judge. These individuals largely promulgated a textualist theory. Bork was more of an originalist / textualist, but Scalia and Black both definitely purported textualist interpretations. All right, and ironically, Justice Black was one of the most liberal members of the court. But during the 34 years he was there, we all know Justice Antonin Scalia was one of the court's most conservative members for the 30 years that he was on the court. And Robert Bork was a very notable conservative legal scholar and judge who had his Supreme Court nomination borked in 1987. Yes, that's where we get that term from. So, while not as much a friend to legislative enactments as an originalist, a textualist judge will typically not seek to invalidate laws unless they clearly violate the specific text of the Constitution. If the law fails to specifically violate the text, no matter how stupid, illogical, or restricting of liberty the law may be, then a textualist, a true orthodox one, is likely to sustain it. So with that said, courts are not likely to interfere, all right, a great deal with the functions of legislatures if they adhere to textualism. Legitimately passed statutes would survive a great deal of constitutional challenges, and courts would affirm their legitimacy, and the democratic legitimacy of those laws would be affirmed. In sum, the rule of law would generally be sustained, and democratic legitimacy would not be overly offended by textualist-oriented judges. So that brings us to the final type of interpretation, and that is the living document approach. A bedrock principle of the living document theory is that the Constitution and its evolution is virtually ordered, okay? With a common law constitution, such as in the United States, societal evolution based on changing circumstances and results, all right, common law, will logically require progressive interpretations, okay, to conform to the era and to the situations at hand. Because we have a common law system here in the U.S., a significant amount of the law is based upon judicial precedents in this country, as we all know. that, while similar, may vary with some degree throughout the ages. The approach is often controversial because many perceive it to allow judges far too much power in their abilities to interpret the Constitution and form conclusions based on contemporary standards, which of course are usually very much to the left of everything. Such is not true, however. Because the living document theorists place high emphasis upon precedent, judges are not typically permitted to significantly and legitimately venture outside those precedents unless significant societal changes warrant it. Okay? An example of how this theorist may interpret the Constitution is as follows. The Eighth Amendment reads, quote, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, end quote. To those believing in the living law, the concepts of excessive bail, excessive fines, and certainly cruel and unusual punishment are very subjective and open-ended concepts, okay? They certainly would evolve as societal mores change, with each passing generation and the formation of new precedents. What was cruel and unusual in 1918 may certainly be different than in 2021, okay? Similarly, the living constitutionalist would have a field day with a broad article like the 14th Amendment, all right? Because of the amendment's very open-ended language, there is much room for the interpretation of the law to fit present needs. Again, precedents play a large role, all right, as do the very real evolutions in societal thinking, okay? Society changes with time. I guess I don't need to tell you that. Now, to the arguments against and for the living Constitution interpretive philosophy. So, as with originalists and textualists, living law theorists have many arguments in favor of this method. These methods describe why the living Constitution philosophy is practically superior to the previous two, Originalism and Textualism. First, the common law interpretation through time is procedurally more logical and law-oriented. In doing so, judges and lawyers use sound legal reasoning from precedents to form new ones, and in doing so, incorporate theories of fairness and policy at the same time. Originalism mandates that judges and lawyers simply be historians, as I've mentioned earlier, not crafters rather of an evolving law. And textualism forces them to be blind to all other circumstances outside the plain text of the law. Second, the common law method applied under the living Constitution gives judges more sound explanations when overruling or deferring to precedents, and thus applying or rejecting the past in current and future decisions. Okay? So, originalism and textualism simply do not provide much guidance on the law's adjustments per se, but rather what it meant, or solely what it says, not how it relates to current times, or even if it has any, real relevance to current times whatsoever. And third, the common law approach focuses upon exactly what is going on right now in contemporary society and its needs, not what went on 200 years ago, okay? We live in a society which now, more than ever, is highly diverse, complex, and ever-changing. Such a society would likely be significantly hindered in that development with a blind focus upon the original meaning of the past, or by a squarely textual meaning of the present, all right? And fourth, with a common law approach, judges can be human beings in their interpretation of the law, and thus take fairness and policy into consideration. This doesn't mean that they can rule however they want willy-nilly, all right? But instead must stay within the sphere of the precedents that they're deferring to or overruling under the right circumstances. So the point is that judges may use the realities of situations to form their decisions within those precedents and shape the law with a more responsible hand. Under originalism and textualism, judges' hands are effectively tied by the past, all right, or the rigidness of the text. And judges cannot display humanistic empathy, all right, or theories of fairness or justice, or anything outside of what those interpretations command. Additional reasons suggest why this method is preferred by many over originalism and textualism. First, the world has evolved considerably since the Constitution went into effect some 230 plus years ago. Society has changed in every way imaginable, and the law must follow the changes of society to still have legitimacy and purpose. Right? Right. Second, because the Constitution is flooded with such open-ended language, they feel that the framers must have intended its provisions to be inclusive and therefore open to contemporary interpretations by the judiciary and legislative bodies. It is, after all, a common law constitution. The third argument is one contained in both prior arguments, and that is because the Constitution contains no official user's guide on how it is to be interpreted. Thus, the living Constitution approach is no less legitimate than the previous two. So opposing arguments to the living constitutional approach are no less passionate in their beliefs. First, they contend that while the world has indeed changed in every way since 1789, it is not, nor has it ever been the role of the courts to alter the meaning of the laws from what they say to what they want them to say. That is nothing more than that old term we've heard, judicial activism, ladies and gentlemen. Second, the Constitution does indeed have lots of open-ended language, but that is not a license by the courts to interpret that language to reach results that it was never likely intended to convey, right? Third, and perhaps most damaging to the living Constitution theory, is the simplest one of all. Located within the Constitution is a section known as Article 5. You've heard me mention it quite a few times in this essay. That article contains the process for amending the Constitution and thus bringing it up to date with the times in the proper format. All right? They would have a better case if the Constitution lacked a section to change its wording, or if the process was logically too difficult, neither of which are the case. And thus the need for a living Constitution is entirely unnecessary when you have a clear mechanism contained within for crafting amendments to bring the Constitution up to date. Fourth, the living Constitution method subscribes to a theory in which the law, through precedential changes, updates itself according to contemporary mores accepted by most of society. Ironically, one aspect of the Constitution's provisions, especially the Bill of Rights and the 14th Amendment, is to protect minorities from majoritarian tyranny. With a living Constitution, the majoritarian principles are superimposed upon the rest of society. Once the Supreme Court decides that it's time to update the wording of the document via its decisions and through case law, it is then beyond question that former Justice Antonin Scalia's statement is entirely one of truth. Proponents of a living Constitution want matters to be decided not by the people, but by the justices of the Supreme Court. End quote. That alone signals why this theory is dangerous to democracy and the rule of law. I'll add one thing that Justice Thomas also made a similar statement whereby, he attacked the living Constitution philosophy by saying that when judges use, anything but the intent, of the framers or what the law would have been understood to mean at the time it was adopted, then those theories have no more basis in the Constitution than last week's football scores. That's humorous, but it's very true. All right. In other words, he's saying the judges are just making it up as they go along if they're not deferring to what the framers would have intended by these provisions. All right. Or how they would have been understood at the time they went into effect. All right. So, fifth, there is an issue in which the living constitution theorists hate to consider, and that is the possibility of societal regression, which, in my opinion, we've seen a lot during the Trump presidency. All right. According to the living constitution theorists, the Constitution's meaning changes naturally over time with precedential succession, thus without the need for amendments. With that, there is the real possibility in which society could revert to a mentality wholeheartedly where racism, sexism, and other evils may again become completely acceptable. Okay? Like I said, Donald Trump's election to the presidency in 2016 makes this more than just rhetoric, folks. Precedents could, be established where those views find their way into constitutional law. Don't think it could happen? Think again, folks. If those things do become socially acceptable again, hopefully it's not in my lifetime or yours, but it certainly could, courts may well interpret the 14th Amendment erroneously, as well as other statutes, as permitting these things as they did in such horrible decisions as Plessy versus Ferguson, 1896, Bradwell versus Illinois in 1873, and other cases, okay? In spite of clear constitutional language to the contrary of the decisions that the court reached in those cases and a litany of others, okay? Under stricter, fixed interpretations of the Constitution, all right, those things could only become permissible, again, should the 14th Amendment be repealed, thus, once again, legally permitting them. Never through mere societal evolution, okay? It is a dangerous thing when the text of the Constitution is not secure and one's very life, liberty, and property may be at stake when it's not, okay? For the above reasons, right, against the living Constitution theory, an existing amendment process only, all right, solidifies those arguments, all right, weakening the argument that societal evolution naturally facilitates the updated meaning of the Constitution's words. Like I said, you got to take things like regression into account. So with that said, the living Constitution theory is likely to conflict with both the rule of law and democratic legitimacy. Living constitutionalists wish to use the courts and superimpose progressive morality upon everyone, for better or for worse. And unlike in the traditional format whereby the political process is used, the people have no say in the matter when it is reduced to private litigation. By having unelected life-tenured judges determine what constitutes proper contemporary societal progress, you undermine both the rule of law and democratic legitimacy. This is so because judges are writing the law as they go along through their opinions, for better or for worse. Once again, nothing is fixed or secure. And inevitably, judicial activism will show its ugly head, all right? With a living law, democratically elected statutes are often enacted statutes, are often invalidated by activist judges who don't agree with them, all in the name of liberty or due process or even cruel and unusual punishment, regardless of precedents to the contrary or a non-evolved society. With this system, the law cannot be said to be truly stable, but rather putty in the hands of untouchable judges. And that is the end of democracy and the rule of law itself. We become a dictatorship of judges, the rule of men, not the rule of law. the rule of men and women, rather, excuse me. Stability in the law is not perfect in every situation, and no one has argued that it is. But it at least does allow one to typically know what the law is and go through the proper mechanisms to change it, thus placing our rights and freedoms on a more solid footing. So to conclude, ladies and gentlemen, these three methods of constitutional interpretation are unique and distinct. And despite this, they have the real ability to overlap. Very few people, whether you subscribe to Originalism, Textualism, or the Living Constitution method, very few people are orthodox, okay? So whether scholar or school teacher, lawyer or layman, every American has an opinion on how the Constitution should be interpreted, be it progressively or conservatively. All of the methods also have a clear effect on the rule of law, democratic legitimacy, and thus how those interpretations will affect legislative enactments in the long term. All right? So that about sums up my long essay. And if you made it this far, I appreciate you for listening on the various types of U.S. constitutional interpretation. All right. My personal preference for constitutional interpretation tends to fall more along the lines of textualism. All right. With a definite tablespoon of originalism added in the bunch. Again, thank you so much for listening to this essay on constitutional interpretation. If you've not subscribed to my channel at this point, please do so, Juarez Lee Shelton, M.A. And if you liked this video, enjoyed it, gained some insight from it that you might not have had before, please drop me a like. You know, that would be appreciated, as well as your subscription. All subscriptions and likes matter. Thank you again. Be blessed. Stay safe out there. And I'll talk to you at the next video. Peace.